A very warm good morning to all of you. I formally welcome you. Dear guys and dolls, today I am inviting your observations, your comments, your contributions in understanding media freedom and primacy of privacy. In this particular engagement, we are going to deliberate media freedom and privacy, individual rights, targeted discrimination, obscenity, pornography, rights of children under international law, under municipal legal systems, censorship, legal regulation of blasphemy, and other important issues which have been affecting and creating a conflict between media freedom and right to privacy. It is indeed a very, very important engagement. We should try to understand the historical background of obscenity and pornography and contemporary standards in child pornography, particularly. That has also created a lot of problems in understanding the idea of privacy and how it is conflicting with the rights of media. At the same time, how to reconcile the historical development of private and confidential information in media practices and human rights. We must try to understand, my dear friends, the significance of the photojournalism in public places. At the same time, it is equally important how to deal with information, privacy and reputation, personal data protection, abuse of the personal information, marketing of personal information, and particularly in an age of internet, and that too internet privacy becomes equally important in understanding all these dimensions. So these are some of the important facets which we should try to understand in this particular engagement. My dear friends, first of all, it becomes inevitable, imperative to understand what is media freedom. My dear friends, media freedom entails the liberty to publish and to distribute content on any platform. And this media freedom also implies that it must be free from the control, censorship, and any kind of a harassment on the part of the state machinery or state per se. While these repressive measures continue to pose a significant challenge, a significant or a vital intimidation, media freedom requires, my dear friends, much more than just the absence of censorship. It needs a proactive protection and fostering of certain important values, particularly within the rubrics of global constitutionalism. International framework, my dear friends, recognize that the enabling environment, congenial environment, conducive atmosphere for media freedom includes the freedom of expression laws, access to information guarantees. On the last occasion, I have also, to a very significant extent, talked of access to information. Civil defamation laws based on international standards and protection for the confidentiality of the journalist sources and whistleblowers. Among other legal and statutory preconditions, my dear friends, amid the digitalization of media sector, media freedom is also predicted on the internet remaining free from what you call, forms of online censorship described in many dimensions. My dear friend, if we are really interested to achieve full press freedom, therefore there are certain important components which I have just mentioned for your consideration that shape the character of media freedom and need themselves to be accompanied by pluralism and independence. That should be what we call understood head on, I should say. And in the frame of the Windhoek Declaration and plus other 30 declarations, my dear friends, endorsed by the UNESCO General Conference, particularly in the month of November 2021, that is last year. Media freedom, media pluralism, and media independence today are also dramatically affected by the rise of internet gatekeepers, the eroding business model for journalism, and the levels of competence of the news media audience to engage with the mass communications and other important technologies, the technologies which have been designed to foster media freedom, and at the same time, so far the negative impact of the technology on media freedom is concerned, the technologies are also being used for surveillance, and these technologies in the hands of the state machinery or the state what we call actors, also to a very great extent it has been seen in the recent years that to a very great extent these technologies have also been abused. My dear friends, according to the major tracking indices, media freedom and freedom of expression have been on the decline in many parts of the world since 2012, I should say. The turning point marked the end of what had been an historic 2-decade expansion in media freedom after the arrival of internet on the global canvas of understanding media freedom. Therefore, to be sure, freedom of expression, freedom of press, or press freedom never change uniformly across the world. The history of what we call the media freedom or history of media evolution is a testimony to this particular fact. Because the uniformity we cannot attain. In any given what we call year, some countries progress while others lost ground. If you take into account, my dear friends, a period between 2015 and 2020, 27 countries saw freedom of expression decline, and substantially, my dear friends, if it is compared with that of the 25 countries from 2010 to 2015, and just 10 from what we call from 2005 to 2010. That is the situation, and this situation has presented innumerable what we call challenges. In most countries, however, the environment of freedom of expression remain unchanged. Through stagnant, maybe a more what we call accurate description or depiction, as the need for what we call progress remains imperative on so many what we call issues. While the decline in media freedom and freedom of what we call expression appears to have shot somewhat in the past 5 years, particularly, or you may also take into account the last 10 years relative to the previous what we call period. The trends included throughout what we call the entire what we call assessment. If you take into account the history of the last 20 years, you will find that it has been very staggering and characterized by some sometimes stubble erosion or subtle what you call erosion of the legal enabling environment. My dear friends, under the cover of transformation, under the cover of what you call of this assessment in the media landscape, including the growth of the online, what we call misinformation or disinformation campaign, and that too in the name of the freedom of the social media, countries are responding with laws, regulations, and policies that endanger media freedom in the long term. Therefore, in many cases, my dear friends, apparent stagnation of freedom of expression is course in global indices may portend what we call future disintegration of the idea of constitutional trust and the constitutional morality that has become the most important what we call foundation for the constitutional right, and that is the freedom of media as well as the free right to freedom of speech and expression. So this is how we should try to understand this entire what we call jargon. There are, fortunately, the ongoing global pandemic had also presented a litmus test in understanding the idea of the media freedom. What has been the threshold of the media freedom, my dear friends, during this global pandemic, which started in our part of the world, that is South Asia, in 2019? My dear friends, during the global pandemic and the uncertainties which have been posed by this global pandemic, citizens around the world scanned their what we call TVs, radios, and other important what we call electronic gadgets and technological what we call gadgets, including newspapers, print media, in all kinds of what we call manifestations, and scrolled down news sites and applications, searching for critical and trustworthy what we call information. But in majority of the situations, it has been witnessed that whenever we access to information on electronic media or internet, there has been some kind of a disappointment. If we believe that the BBC is the a trustworthy, or the CNN is trustworthy, then it is not playing its what we call role when there is a question of what we call of the involvement of Russia in Ukraine. Even at global level, the media houses are divided on political lines, on ideological what we call lines. When we see our own media and its freedom in South Asian jurisdictions, then definitely the media houses in their individual capacity, they have also deposited their loyalties in different what we call political establishments. So how to find out a trustworthy media platform? That is the $1,000,000 questions. How was the government responding, particularly the media freedom during this particular global pandemic? Was it safe to go for the work or the shop for food? When would be what we call when we are going to witness the end of what we call of this global pandemic? My dear friends, not everyone found the information they needed. Often news media struggle to keep up with the demand, a task made at the more difficulty by accelerated declines in revenues and limited capacity, especially for local newspapers and outlets, particularly in global South. And some audiences, instead, they have found misinformation and disinformation. They have been confronting with the miasma of myths, rumors and refinements, naked and flagrant lies, and in such quantities as to be dubbed as, I should say, disinformation. Disinformation, and that too in an age of what we call of global pandemic. We have been receiving misleading information. Such falsehoods, therefore, spread intentionally or not, solved confusion, division, and discord, impacting lives and livelihoods around the world. This has been the what we call role of media, and that is why When we talk of the media freedom, then we should also what we call, take into account what exactly the role media has been playing in the human rights, in environmental what you call, degradation, or environmental, issues, disarmament issues, international relations issues, and foreign policy issues. We should not what we call, blindly believe that this is the what we call, and we should always argue for media freedom, because in recent years it has been, witnessed. And yes, on the last occasion I have also submitted, my dear friends, that media has emerged as a, new state organ, but how it has been, discharging its obligations, because a lot of credibility, lot of what you call, political socio-economic weight has been attributed to the media freedom. So how it has been responding to the issues of the common man? My dear friends, the ability to cause large scale disinformation and undermine scientifically established facts is an existential risk to humanity. And I am not saying this. This has been noted, my dear friends, by the collective wisdom of the United Nations Secretary General, the current Secretary General, Mr. Guterres, when he has submitted his report with this kind of a, agenda, which is known as our common agenda. My dear friends, United Nations Secretary General opined that while vigorously defending the right to freedom of expression everywhere, we must equally encourage societies to develop a common empirically backed, consensus on the public goods of fact, science, and knowledge, without which we would not be in a position to appreciate the different what we call, contours of media freedom. Therefore, my dear friends, this is my well-considered understanding that the journalists have been denied access to information essential for providing a clear and accurate what we call portrayal of the spread of this kind of a, whether it is diseases erupted in the form of, coronavirus, or some other kinds of what we call of, issues and information which is germane to the welfare of the, humanity, including basic data on the number of what we call of, cases, whether pandemic related cases, genocide related cases, or the crimes against what we call, humanity cases, crimes against, minorities in various geopolitical entities. They have been, to a very great extent, I mean, the journalists have also been independent journalists. I am talking of impartial journalism, those who have been carrying out the mandate of, international standards of journalism. I am talking of those, journalists. They have been barred from attending briefing or spreading to health what we call care workers and health officials. They have been subjected to laws that purported to limit the spread of the, misinformation or disinformation, but instead curtailed independent journalism. And that has become the bone of contention in the corridors of, powers and power structures, which have been what we call, erected with the active support of the state machinery and state agencies. So that has created some kind of a, miasma. At the same time, they have also been faced worse, direct, censorship, arrest, threats, and other, and this is something we have been witnessing on daily basis. Recently, I think 3 or 4 days back, or 3 days back only, in Pakistan, a journalist has also been what he call, tortured, and you can arrested. You can very well understand. Myanmar is another important, example. Even in India, we have been, witnessing what kind of a treatment journalists, independent, impartial, journalists have been getting at the what we call level or by the state machinery and its, officials. Therefore, my dear friends, journalists and media workforce of all kinds are crucial to helping us make informed, decisions. And during this particular, crisis of the global pandemic, those decisions can save lives. Now more than ever, we need that media to document what is happening and differentiate between fact and, fiction, and hold leaders accountable. And we cannot what we call, hide our eyes what exactly, happening in our, backyard, if I'm speaking as an Indian. So I cannot what we call ignore what is, happening in Sri Lanka, in our neighborhood. We can very well understand what kind of a situation has been created by the government and its machinery, how they have been, I mean, the colonies after decolonization in South Asia, or the decolonization at international level, or how the decolonized what we call societies in the global south, how they have been behaving, and their governments have been behaving towards their own citizens. Britishers believed, my dear friends, divide and rule, and now the decolonized governance establishments, they have shifted their eyes from the British what we call model of the divide and rule, and they have adopted divided to rule. So the societies and the citizens are being divided on different what we call lines. Sometimes they're on racial lines, sometimes religious lines, sometimes caste lines, and they have been what we call ruling. But ultimately, what we have been witnessing, my dear friends, a new kind of what we call of colonialism, homegrown what we call colonialism. This is what I try to understand it. In such a scenario, what is the what we call, and what should be the level of media freedom, and how the privacy should be what we call maintained? So this is how we should try to understand, because since the pandemic began around the world, many journalists have been subjected to increased what we call restrictions, disproportionate punishments, intimidations, simply for doing their job. While temporary constraints on freedom of movement are essential to beating the what we call global pandemic, but at the same time they must never be used as a pretext for cracking down on journalists' ability to do their work. But we cannot what we call issue some kind of a clean sheet to all kinds of journalists. So far the behavior and the role of journalists is concerned in maintaining media freedom, I would also be what we call taking the later part, particularly the second important part. So far the impartiality, independence, and journalistic what we call ethics, including the safety of the journalist, in the next what we call engagement. But what is important at this stage is to understand the idea of what we call of the media freedom. If you can take, if I share with you, my dear friends, media freedom, particularly between 2020 and 2021, or up to what we call March this year, you will find that 102, my dear friends, have been instances so far the access to restrictions are concerned, and there have been more than 200 arrests which have been what we call made, and the journalists have been charged. And there have been, my dear friends, globally speaking, 95 cases of censorship, and more than 200 what we call verbal or physical attacks on journalists in a one single year. So that is the data, and this has been documented by the international what we call agencies. And some governments have used the pandemic, my dear friend, as cover to crack down on many forms of the democratic rights. But restrictions on the media are the most common by far, or violations of the democratic standards, according to some of the international what we call agencies. And particularly this reminds me of a very recent report that has been what we call released by the VDAM Institute. So this institute has also been working in media freedom, and they have also published the entire what we call data, how the journalists and what kind of attacks have been made on the freedom. My dear friends, this is a very flabbergasted kind of what we call scenario at international level so far freedom of media is concerned, and what exactly has been the impact of the media freedom on right to privacy. So this is how we should try to what we call address. Is there any observation on your part?
Sir,
Yes, ma'am.
yes. So in line video submission, I think so. You have posed a question like in such a scenario that you have presented. Uh, like you have posed a question of how privacy could be uh, maintained,
Hmm.
and I think so. Looking at the circumstance and the situation that we are in the present times, I think so. It is uh, an important question, as we can see there is a very much access to information plus disinformation and misinformation also, and I think so this is an important like question to analyze in the circumstance that we are in.
Ma'am, it's a very, very important observation which you have made. But at the same time, how to maintain media freedom, it is basically important to understand that there are certain important frameworks. And these frameworks are important in understanding the entire idea of, media freedom. And particularly being a student of international media law as well as international law, it is important to understand that the media freedom can only be understood and should be maintained if we are adhered to the entire what we call international perspective. My dear ma'am, we should try to understand right to freedom of media as a fundamental human right or as a fundamental human rights of an institution. There are international standards, there are international frameworks, particularly the Universal Declaration of Human Rights, International Covenant for Civil and Political Rights, Rio Declaration on Environment and Development of 1992, UNESCO Declaration of 1978, and regional legal instruments, particularly American Declaration of the Rights and Duties of Man of 1948, then the Rome Convention for the Protection of Human Rights and Fundamental Freedoms of 19 what we call 50, then American Convention on Human Rights, that is particularly known as the Pact of St. George of 1969, if I am correct. Then the African, what we call Charter on Human and People's Rights of 1981, framework, convention for the protection of national minorities, Asian, what we call, declaration on human rights of the 2012, and the Arab Charter that cannot be what we call, forgotten, whether Asian or the Arab charters are in active, mode or not, it is immaterial, but substantive normative understanding has been achieved by this particular region of the world in 2004. Then international principles are also, there, particularly United Nations principle of 2000 and the Inter-American Declaration on the Principle of the Freedom of what we call of expression and media freedom, that is again of 2000, that should also be taken into consideration. So what is important is that so far the international framework is concerned, ma'am, there is no dearth of what we call of law, but whether we have been able to what we call legislate within the municipal legal system, whether we were able or the national governments inclined to have some kind of a legislation or translate their international endorsements and commitments within the national jurisdictions, that is another important challenge, because in majority of the situations it has been witnessed by all the stakeholders that the national governments approbate their international commitments, they submit their instruments of ratifications under the article 102 of the United Nations, Charter. They submit their instruments of ratifications with the Secretary General of the United Nations, organization, but they failed to translate those international endorsements, obligations, commitments, convictions within the, national jurisdiction. And that has presented a lot of what we call it, controversial, or generated a lot of controversial issues. And ultimately, the biggest victim happens to be the two important fundamental rights within the national jurisdictions. So that is one, the media freedom, and the fundamental rights, how to seek information, how to what we call, access to information, how to ensure transparency within the national what we call, jurisdictions. So what is important is that there is a need, man, to have a legislation compatible with international commitments without any kind of a political peepering or the political what you call controversies. Yes. Any other important dimension on your part which you would like to further raise? Yes, Miss Karishma.
Yes, sir. Sir, the legislation, the needful legislation in context with media freedom is what you have stating. No?
Pardon, I'm not getting.
Sir, as you said, the needful legislation in context, like in context to media freedom.
Yeah.
Oh, yes, sir.
Yeah. Apart from the international framework or international instruments, there are, legislations within the municipal legal system. A utopian kind of legislations have been enacted in Canada, in United Kingdom, in United States of America, in Sweden, in South Africa, even in India. We are also having a legislation in India, Information Technology Act of 2000. There are, in all the South Asian constitutions, adequate constitutional provisions have also been arranged in the schematization of the constitutions and constitutional order. Right to freedom of speech and expression has been recognized as a fundamental right. Free media has also been sanctioned under this particular, right. But implementation has created all sorts of, problems. Primacy of one political line has created a lot of, controversies, because it is in the DNA of governance institutions across the jurisdictions that governments are not in the habit of broking any kind of a resistance or any kind of a criticism. Governments do not tolerate any criticism, even if it is going to be the fair criticism. Therefore, despite the fact there are, legislations, even then, we have been, witnessing a lot of what we call governmental institutional interventions. And these interventions have been construed as some kind of a restrictions, limitations on the exercise of this fundamental right of the media houses, and that is freedom or media freedom. And to a great extent, even the media houses or the media, what we call, freedom has also been, compromised because of the behavior, because of the, approach of the media houses. Remember one thing, whether we are living in Germany or, Canada or in England, what is important is that the laws, it should be the what you call responsibility and duty of the ordinary citizens to abide by the law. Anywhere in the world, law does not fail, or the laws do not fail. It is the, citizens, it is the subject matters, it is the what you call, agents, or the applicable what you call, or the laws who are going to be applied to a particular, geopolitical entity, the citizens of that geopolitical entity have been failing those very laws. The governments are the biggest, what you call, national governments are the biggest, what you call, culprits, I should say, in undermining media freedom. Constitutions do not fail. We, the people of the world, have been failing our constitutions. Otherwise, the constitutions have been enacted with the best of what we call of the, investment of the collective wisdom. And we have been failing those what we call, promises and goals. So if you take into account the legal and statutory what we call, trends, much of the backsliding in media freedom derives from more what we call, subtle or indirect forms of restrictions and the legal what we call, threats. In each and every geopolitical entity, my dear friends, you will find that each and every geopolitical entity has become a powerhouse of legal contradictions. There are laws whereunder we try to exercise media freedom or the freedom of speech and expression, but at the same time, there are laws who restrict and create impediments in the realization of those very freedoms. Yesterday, also the sedition decision that has been what we call, I mean, Honorable Supreme Court of India today handed down is a judicial what we call, understanding with regard to a particular, provision that has been incorporated in the Indian Penal Code as Section 124A on sedition. Now, how it has been used by the state? You can conduct a survey. You can conduct an empirical study on this particular, that is how in 21st century, in the last, 20 years, this or more than 20 years of the 21st century, more than 2 decades of the 21st century, how this particular provision in the scheme of Indian Penal Code, this particular section, how it has been used by the state. Whether the usage of the, of this section by the state, how the state of India has invoked this particular, section of the Indian Penal Code against the ordinary citizens, against the, media houses, against, journalists, against, social activists, what has been the conviction rate, how it has been responded by the state, and how the civil society institutions reacted to the misuse of this particular piece of provision, and how it has become incompatible with that of the, part 3rd of the Constitution of India. That, describes that what we call, that is the repository of the fundamental human rights and fundamental human freedoms. So there are, contradictions. Article 19, subclause 1A of the Constitution of India provides freedom of speech and expression, and that includes media freedom as well. How it has been exercised? When somebody, Mr. A, is exercising legitimately, constitutionally, and reasonably this particular, right that has been granted under Article 19, and how that particular, gentleman has been restricted by the state. And in some cases, even Section 124 has also been, invoked. So how to create some kind of a reconciliation? If you are not, satisfied and with my any of the actions, if I am, taking, if you are not, appreciating my line of argument, if you are not comfortable with my research approach, should I appreciate your opposition or should I go against you? Should I offer further, alternatives? Or should I listen your line of argument? Should I allow myself to be convinced by you? What kind of an alternative should I choose? Or simply I should, direct and I should what you call, victimize you? This is not my cup of tea. If you are saying something against me, I must listen to you. I must listen you on merit, with an element of objectivity. I should apply my judicial, mind, because we are a civil society. We are an educated, what you call, community of teachers, community of students. We should appreciate each other's, what you call, intellectual positions, ideological, affiliations. Even among the student community of the South Asian University, there are students who are having different, what we call, ideologies. And their ideologies may be at variance with that of what we call of my ideology. So that should not be the bone of contention. That should not be the, a critical, what we call, contest. And therefore, since I happen to be in a dominant, position, and I am having some grades in my hands, so I should, victimize you. No. I believe in the complete departmentalization of our activities. Your answer sheets are different, your dissertation is different, your ideologies are different. Your line of, what you call, of inquiry may be influenced by your ideologies, therefore I should appreciate. I should also offer some other alternatives as well. Yes, you stick to your approach, but you should also be the mindful of this particular fact that this particular ideology is not the only ideology that is espousing this cause, but the same cause has also been, what we call, defended with this kind of, ideology, and therefore we should also try to understand what exactly are the contours of a different ideology. My way is highway kind of, approach is very much, detrimental to the entire, what you call, philosophy of higher education and intellectual liberty. But this is something which is missing, because the media freedom and media propaganda, these are the two different, what we call, notions. And what we have been, what we call, witnessing, we are not witnessing media freedom in public domain around us. Rather, we have been witnessing media propaganda around us. That is my understanding. I may be wrong, and I deserve, my dear friends, further, what we call, deserves to be enlightened with the different, what we call, approaches. Any observation on your side? Yes, Miss Apurva, what about your health? Are you fine?
I'm recovering, sir. Thank you for asking.
Yeah, I consulted because I received a message from Stalina ma'am. So I consulted my younger brother, who is an orthopedic surgeon. So I consulted him and I submitted that the clinical examination is required in the persons of patient. So I sought his opinion on the basis of your report,
Okay.
which, yeah, I received it from her. So you are recovering now. I hope in the right direction.
Yes, sir. Yes.
Yeah. Yeah. Please take care of your health. Health
Thank
should be given the first priority, and thereafter we can manage each and everything.
Thank you, sir. Thank you,
You're
sir.
welcome. Yeah. So, any other observation, Miss Purva, on the point which I am raising? Would you like to contribute something?
Yes, sir. I have been just trying to process the factor that the current situation, if we take, for example, in India or in China or in US, most of the mainstream news channels act as mouthpiece of the government, and there is some non-mainstream subaltern spaces, but it has kind of become an echo chamber where people were already aware of the issues, read and learn about it. And on the other end, media is also kind of flaming the anti-minority sentiments everywhere. On the other end, there is also an increasing um, destruction of space for conversations that are critical of the government. And it's not just sedition. Now we have UAPA, and if the Shreya Singhal judgment post that if not one section, they use another section to file charges. So, and also the whole national security provision. What is national security? The definition itself has been so arbitrary, and the court has never tried to define it, which gives a lot of space for the government to put everything under the banner of the national security. And also that if we take the case of criminal conspiracy, there is no need to prove anything for the prosecutor. They can just put someone in jail and they'll be under trials for a prolonged period of time.
Yeah.
And we should, while we question the constitutionality of sedition, while we question whether UAPA is constitutional or not, there is also a larger question of how do we carry forward the process of decolonization of laws and the function of governmental institutions, police, and everything. That's a very larger question, the reformative question that we need to address, I think.
Yeah.
That's
Very
it.
true. Yeah.
Thank you.
Yeah. Thank you. Thank you. I completely in agreement with your observation. Yes. Uh, Absolutely correct. If you take into account international standards, criminal sanctions for speech in any form, verbal, written, or recorded, should be applied only very exceptionally, I should say, and as a last resort in the most severe cases, and such as those involving incitement to imminent violence. In contrast, criminal defamation laws in any form are widely seen as a disproportionate ways to deal with alleged violations of dignity and reputation, whereas civil penalties do not constitute a threat to freedom of expression and media freedom. The gradual progress you have rightly pointed out towards the decriminalization of defamation, if I take defamation as a case study, has slowed in the last what we call a decade. In the last, I should say, almost 6 or 7 years in all regions, except what we call, Africa, where momentum remains strong. And according to latest UNESCO data, at least 160 countries still have criminal defamation laws on their books, and that is down from 166 in 2015. And these laws are finding new life through strategic lawsuits against public participation, and in libel what we call terrorism, through which powerful actions initiate lawsuits in countries where defamation or libel laws are easier to abuse for the purpose of silencing critical what we call voices, the critical oppositions, or I should say critical fair oppositions. So this has become some kind of a vendetta on the part of the governmental machinery. And at the same time, ma'am, a raft of new laws have also been passed in the last what we call 6 or 7 years, and that purport to take aim at misinformation and disinformation, cyber crimes, or hate speech, but with the potentially grave implications for media freedom. And at least almost what you call 57 laws and regulations across more than what you call 40 countries or 40 to 45 countries have been adopted or amended since 2016 that contain overly vague language or disproportionate punishments that threaten online what you call freedom of expression and media freedom. And among them, you have rightly pointed out the idea or one particular narrative, that is the national security narrative. And how to define national security. It has become of late very subjective. Because right to privacy and media freedom both have been what we call slogged under the weight of both the rights, both the fundamental rights, my dear friends, have been tottering under the weight of the national security narrative. Nobody is in a position to define what is national security. Nobody is in a position to define what is national interest. Nobody can define what is nationalism. Because the traditional definition of nationalism, you understand, I understand. You understand what is national security, I also understand national security. But when we try to exercise our fundamental rights, when we try to what we call materialize or realize and try to what we call enjoy our fundamental rights, then the national security idea of nationalism or concept of nationalism, an idea of national security with a different orientation is presented before us. And we, the citizens of any geopolitical entity, fail to understand these are the contours of the national security. Without any kind of a verification, without any kind of a corroboration, without any kind of substantive arguments, the people are being what we call jailed, pending trial. So in such a situation, we have created a kind of a police state, and there is a global trend, whether it is Spain, whether it is North Korea, whether it is Austria, these kinds of advanced, well-developed nation states, and the recent what we call communal clashes in Sweden, these are some of the important examples. So it is very difficult to understand, and there is a need to create and to have some kind of a reconciliation between these kinds of narratives, the national security narrative and media freedom, and right to what we call privacy. So this is how we should try to understand this entire what we call argument. Otherwise, it would be very difficult, because in accordance with the international standards, any limits on freedom of expression should be legal, necessary, proportionate, proportional, and pursuant of legitimate objectives. But at the same time, my dear friends, there have been studies examining these new laws have been found or have found that many do not adhere to these international standards, which have been incorporated under Article 19 of the Universal Declaration of Human Rights. And at the same time, my dear friends, it is a question as to whether such restrictions have any meaningful impact on the drivers or effects of misinformation or disinformation, given that many are justified as having this ambition, or whether there is more likely to be a chilling effect on the media freedom and freedom of speech and expression. So therefore, my dear friends, we should try to understand, we should try to address this kind of controversy, because at least 57 laws and regulations across more than 44 countries have been adopted or amended. But as misinformation and disinformation and hate speech continue to spread rapidly, my dear friends, particularly online, many legal and policy measures have been sought to address this challenge. However, vague or disproportionate provisions in any kind of laws and regulations can have a negative effect on the freedom of expression. So therefore, it is our fundamental responsibility to understand that these kinds of what we call of notions must also be what we call litigated and contested. If you take into account, my dear friends, 2030 agenda for sustainable development goals, which on earlier occasions I have pointed out, my dear friends, recognizing the fundamental importance of access to information to the public is fair governance and development by including target or the global goal 16 to ensure public access to information and protect fundamental human freedoms. So that constitutes a very, very important notion, because according to data available in public domain, over the past 5 years, at least 22 UN member states adopted constitutional, statutory, and policy what we call guarantees for public access to information, bringing the global total to 132 UN member states as of last year, up to the month of August 2021, if I am not wrong. My dear friends, it is equally important the challenges in the area of what you call the freedom of speech and expression remain, and the data which is available. But this data lack, my dear friends, strategies for the implementation or suffer from poor resourcing to the agencies responsible for any kind of overseeing or for any kind of supervision. The quality of laws which have been in recent years enacted also remain highly variable. Some laws do not include adequate reporting requirements, while others provide overly broad language for exemptions, such as the types of what we call of information that should not circulate in the public domain, which can give governments an excuse to deny requests from citizens and journalists for information that could be used to hold officials to account. My dear friends, information commissioners are often not independent from the government, and there are not always alternative routes to requesting access. Looking ahead, key challenges will be, my dear friends, access to underlying data held by the governments as well as that held by the private sectors entities that impact public interest and public what we call welfare at large. And therefore, it becomes necessary, my dear friends, to understand the freedom of expression in an age of the digital technologies and try to understand what exactly has been the impact of digital technologies when we are talking of freedom of speech and expression as a fundamental right and media freedom. Because the relationship between freedom of expression and the internet that has been acknowledged in the United Nations Secretary General's what we call report as well, and this report has been captioned as roadmap for the digital cooperation, is now very extensively recognized in international what we call framework. Internet shutdowns have been repeatedly highlighted by the bodies such as the United Nations Human Rights Council as the key human rights challenge on the rise. While many international frameworks and national laws now protect the freedom of expression and media freedom on the internet, and these principles remain severely threatened so far their implementation is concerned, so far their active practice is concerned, and so far the real world of internet is concerned. Because the modular and the decentralized nature of the internet was thought initially to make it more difficult for a state to control or restrict that the analog technologies that preceded it. On the whole, my dear friends, therefore, that remains true, but connectivity choke points make for vulnerabilities that are being what you call exploited to limit freedom of expression and press freedom in the digital what we call orbit. That is very very important. And the similar point was also raised on the last occasion by Mr. Sagar Verma. He is not, unfortunately today he is not here. He raised that what would be the future of what we call of technologies if the private sector, say, if I am correct in my recalling, because we were discussing on the last occasion, and the Sagar Verma was right when he was asking what would be the future of Twitter when it is being, or it has rather privatized and it has been bought by Elon Musk by paying 44 billion US what we call dollars. So what would be the fate? Because it does not remain a public entity, it has become a private entity. But recently, if you go through the last week's statement of Elon Musk, you will find that very soon he is going to what we call make it again a public limited company. And but between this particular period of restructuring, period of what we call of the rearrangements, the period of what we call of regig, I should say, what would be the future of Twitter? So whether it is going to promote the industrial interest, the private interest of Elon Musk and its what we call corporations or other important multinational corporations managed and headed by Elon Musk. So whether it is going to serve his industrial and business what he call interest, that it still remains to be seen. So what would be the freedom of speech and expression on such a or one of the most important and robust platforms in the current what we call situations, or in the current scenario of media freedom at international level? So this is a very, very important question. And this is my humble submission to all of you, that you should also try to understand, also try to what we call, respond to this kind of a, trend. Another important, controversy, another important, situation which we generally address, my dear friends, in case of any kind of a public emergency, whether it is the global pandemic, whether it is some kind of a, constitutional breakdown in a geopolitical entity where, or in situations of the generalized violence, massive violations of human rights, any kind of a, aggression or violations of the territorial integrity or international armed conflict or civil strife, or any kind of a, non-international armed conflict. In these kinds of situations, we have been witnessing some kind of a, activity on the part of each and every geopolitical entity that is generally pursued in the form of what we call the internet shutdown. So why the governments are going for internet shutdown? Even in our part of the world, various governments in South Asia, on many occasions, these governments have also resorted to internet shutdown. What is the reason? Why? Can you tell me? Anybody? You can offer your comments. Why the governments generally go for internet shutdown? My dear friends, internet or an internet shutdown is often defined widely and broadly speaking as the government restricting internet access for large swaths of territory. The most blatant and well-known method of restricting freedom of expression online. That is the basic and the most fundamental understanding of internet shutdown. However, there are several more subtle approaches than the blatant what we call or flagrant shutdowns, provided the technology capacity and expertise. Access Now, a non-profit what we call organization within inverted commas, Access Now, that works to counter such what we call online restrictions, records 6 type of shutdowns, all of which are included, my dear friends, in many reports which are in public domain. If you take into account internet shutdown and its variations. It starts with what we call number one, the broadband throttling, the intentional slowing of internet service or type of internet traffic by a internet service provider. That is first important step, which is generally resorted by the government. Another one is the broadband internet shutdowns, cuts to internet access via broadband, such as in a home, office, or business. Then mobile internet shutdowns, we have also been witnessing. Internet blackouts or the blanket internet shutdowns. Then mobile phone call and text message network shutdowns. And again, service specific what we call platforms shutdowns. These kinds of shutdowns are also, and these are generally resorted by the governments. Suppose in northeast of India or in Baluchistan of Pakistan, there happens to be some kind of a demonstration, and the government of the government of India and government of Pakistan, or the government of what we call of Bangladesh, in case of any kind of a mass demonstration against the government of Bangladesh, are of the view that it is likely to damage the image of law enforcement mechanism, and there is a possibility of what we call possibility of impugning the human rights records of our respective governments, then in specific what we call territories, they may resort to internet shutdown. Sometimes law enforcement agencies also recommend, because of the communalism, because of the racial rights, because of the linguistic rights, because of what we call of cultural chaos, just to control, just to maintain law and order, they also resort to internet shutdown in national interest, in the interest of what we call of, again, national security, and that narrative comes into picture. Just to stop any kind of a rumor mongering, because of, or just to stop the spread of any kind of rumors. So if you take into account the most recent UN Human Rights Council resolution on the promotion, protection, and enjoyment of human rights on internet, condemns categorically, I should say, the measures in violations of international human rights law that prevent or disrupt, my dear friends, an individual's ability to seek, receive, or impart information online, including internet shutdown and online censorship. So that is the legal standard. That is the the provisions. That is the mandate of the international human rights law, and that should also be taken into consideration, because internet shutdowns reached a peak of what we call of the 200 or more than 200 unique incidents in a one single year, and this reminds me of a year that is 2019. Though it is too easy to say, my dear friends, whether 2020 indicates, or the 2021, or whether the 2022 this year indicates any kind of a declining trend, because the internet shutdowns can be conducted nationwide, but most are targeted at specific cities, specific what we call swaths of territories within a particular geopolitical entity or regions, and can last for hours, days, and even in rare what we call cases, months. And this is what we have also witnessed in South Asia. You can very much you are well acquainted to recall those portions, those territories where the internet shutdown was used by various governments in South Asia as one of the most important law and order strategy. So you are in a better position to understand my line of argument. My dear friends, analysis. Yes, ma'am. Miss Apurva. Yes, most welcome.
Sir, when I was interning in Kashmir for a couple of months, there was an internet shutdown going on, and there was this question as to who orders for internet shutdown. At that point, it was like 5 years ago. So at that point, they were not sure as to who has the authority to conduct internet shutdowns. And there were RTIs filed to figure out whether district magistrate does it or the government does it? Who does it? And now the government just uh, asks the, like, it just shuts it down. There are orders directly passed from the government. It's somehow considered as part of the law and order mechanism. But how do they justify it? Like, from where do they draw the power or authority to conduct internet shutdowns?
Basically, internet shutdowns have been, I mean, the mandate to go for shutdowns is basically how to maintain law and order in a specific region, in a specific area, in a specific state, province, or as a whole, an entire geopolitical entity. It is basically in case of South Asia. It is the responsibility of the Muslim Ministry of Home Affairs, whether it is Pakistan, Bangladesh, Sri Lanka, or it is directed by the political bosses, the political executive. When I am using the word political executive, I am talking of the president or the prime ministers and council of ministers. They have been specifically entrusted with this responsibility of maintaining law and order throughout the territory of a particular geopolitical entity in case of South Asia. Similar steps and similar constitutional arrangements are also available in other geopolitical entities. Because when the laws have been made, whether it is the information technology legislation in India, whether the similar kind of legislations in our neighborhoods or nation states, or at a global level, if there are apprehensions which may what you call jeopardize or can jeopardize peace, tranquility, law and order, and actions which may result in the violations of the public order and morality in a given situation, then appropriate measures may be taken by the government and its instruments and its agencies. And it includes the shutdowning of internet platforms. So there are some specific legislations, but specifically it has not been mentioned how to shut down, but appropriate measures or otherwise these kinds of terms are used in the legislations. So therefore it is the Ministry of Home Affairs, it is the legislations like information technology, it is the cyber crime what we call legislations. These legislations empower the government and agencies to go for any kind of a shutdown, and they have to what we call justify. But at the same time, how the governments have been justifying their actions, that has to be judicially appreciated on the basis of what we call the judicial review, if we are going for, or if we are going judicially impugn before the court of law any of the actions of this sort. Because I feel as an individual, I feel as a student of international media law, I feel as a student of international constitutional law, that internet shutdown is a violation of Article 19, subclause 1A, as per the Constitution of India. So that is a violation of the right to freedom of speech and expression, and at the same time, it is a violation of the internet freedom. But legitimate regulations cannot be denied. The legitimate regulations of the free speech is of vital what we call importance. When we are talking of the freedom of speech and expression on internet, it does not mean that we should indulge in kind of a hate speech on internet. That is why today people have been impugning, and it is one of the most important line of argument that was also presented on behalf of the government of India yesterday before the Honorable Supreme Court of India, when it has expressed some reservations on one of the most important section of Indian Penal Code, that is section 124A on sedition. How we are going? It's a colonial insertion in the schematization of IPC that has been drafted, enacted by Lord Macaulay in 1860. So its constitutionality, legitimacy, validity, because there has been a drive, under that very drive, more than 1,500 colonial legislations have already been removed from the statutory books in India. So whether it is going to be relevant, should we retain this particular, section? As I have, a moment ago, I was, talking of contradictions in case of, lawmaking. So every piece of legislation, whether the shutdown, its legitimacy of the shutdown must also be tested on the anvil of the judicial review. Whether it is going to be, compatible with the part 3rd of the Constitution of India, or in case of, Nepal, whether it is going to be the, compatible with that of the part 3rd of the Constitution of, Democratic Federal Republic of, Nepal, or whether instrument or the instrument of policy instructions, how it has been, enacted or inserted in the Constitution of Bangladesh, as well as, Constitution of Pakistan, we have to have its, legitimacy tested on the basis of, judicial review. So shutdown, sometimes liberal societies are having a different, what you call, or liberal democratic societies are having a different kind of, understanding of shutdown. And we, a newly independent nation states, those who have been, or rather subjected to some kind of a colonization, they are having a different kind of a, understanding of, democracy. So we have to have some kind of a, cross fertilization of the democratic values, the constitutional values, because shutdown to me is having a different kind of a, value understanding, a different kind of an interpretation. You are having a different kind of an interpretation of the, shutdown. I am of the view that whenever any shutdown is, taken, whenever any kind of a book is, banned in a geopolitical entity, it is basically the business interest of a particular, publisher or the writer that is also, served. In case of, shutdown, some kind of a hype is also, created. In many situations, suppose in South Asian nation states, individuals are protected by the police and armed, what you call, officials. At every stage of their, movement, their mobility is always what you call, manned. Whenever in United States of America or in London, Prime Minister goes from one place to one, there is no security paraphernalia, because they have, secured their borders, their installations. And that is why they are having less, security in the public domain, at public, what you call, places. But the situation is different in our part of the world. Here the installations are, secured. Industrial armed forces have also been raised in our, nation states in South Asia, because of the insecurity that is available at our, borders. So if we are not in a position to manage, to maintain law and order, if we are not in a position to secure the citizens of the country in South Asia, therefore we generally resort to these kinds of, cosmetic measures. Let us have, shutdown of internet, shutdown of what you call of, telephone lines, shutdown of what you call of the mobile phones, slowing down of the internet connectivities. It is basically a manifestation where we try to understand whether the governments are shirking their, responsibilities. They are running away from, responsibilities. Otherwise, I feel that there is no need of shutting down of what you call of, internet. Because if you take into account any kind of a, or analysis of the entire, internet, shutdown narrative, you will find that the perpetrators of internet shutdowns often try to justify them as a what you call precautionary measure. It is the word generally that is resorted, or as a matter of related to the national security, public safety, or hate speech curtailment, rather I should say, when the underlying motivations appear strongly correlated with moments of the political instability, protest, and communal violence, or even during elections. There should not be any kind of a swaying of election, and there should not be any kind of a polarization of elections or any kind of an impact on elections. So this is how we try to what you call manage and try, and the governments in our part of the world, they resort to internet. Any other supplementary contribution, ma'am? Yes, Miss Apurva. Anything else? Well, let me clarify further. Some governments in our part of the world, or particularly I should say in global south nation states, they are also increasingly investing in their capacity to filter and throttle internet. At the same time, blocking certain kinds of content or slowing down access to discourage users from seeking information online. My dear friends, filtering can be used to block specific websites within a particular geopolitical entity or in a particular nation state, such as foreign news websites or specific social media platforms. It can also be done through more sophisticated manipulations of the algorithms, I should say, that determine what content people see on the internet when using search engines or browsing social media websites or social media feeds. It has also been illustrated, my dear friends, in 2021, I mean last year, there have been some revelations regarding the use of Pegasus spyware. And this is my understanding that all of you are well aware. Some geopolitical governments have also invested online surveillance capabilities. And these capabilities have been energized, I should say, to monitor opposition figures, social activists, including journalists. And the use of spyware puts news financial burdens on news vertical outlets, which ultimately encourages self-censorship and has significant implications for the safety of journalists. It has also explored in greater detail elsewhere. I mean, in addition to journalism, many other important fields have also been put under surveillance by the state. And these tactical assaults, I should say, on press freedom are also far more difficult to detect and deter, and ultimately posing a vexing challenge to the global effort to safeguard freedom of expression and a free press. So Pegasus controversy is another important dimension, how technologies, the digital technologies has impacted this entire idea of privacy, entire idea of the freedom of speech and expression or media freedom. Because we should not forget that the media freedom is that liberty to report, to distribute all kinds of news, but at the same time it should not be in conflict with the right to privacy. That is another important dimension which I draw your attention to. Therefore, If you take into account certain important, reports which have also been, provided by Google, by newly constituted and newly incorporated company, and that is known as the metaverse, where we find Twitter, where we find Facebook, and the newly acquired what we call, Twitter by Elon Musk. If you go through the reports of these, technology giants, I should say, the number of content removal requests received by these, platforms, by these, companies, from court orders, law enforcement agencies, and executive branches of the governments worldwide, have ultimately doubled in the last 5 years to the total of approximately more than 1 lakh requests in 2020 alone. Therefore, the growth of, content removal request has stirred concern that some actions might be abusing the entire, platform's community standards and terms of service by filing unjustified content removal request as a statutory, as a, strategy, as a, practice to suppress dissent or criticism. This is this is the argument which is generally offered by these giants. Suppose I can give you an example from India. Mark Zuckerberg, when certain hate speeches videos which have been uploaded on Facebook, and it was, brought to the knowledge of the Mark Zuckerberg, despite many requests from the, civil society organizations, the instant reaction of the Mark Zuckerberg was that if we remove, it is going to what we call, compromise, it is going to, decimate our business interests. So therefore, in the name of the business, what we call, interest, in the name of promoting and fostering business, what we call, concerns of these, giants, they haven't removed hate speeches, anti-minority or anti-ethnicities, videos. So that is the general claim which is generally, offered by the ownership, by the owners of these, companies. But at the same time, it is equally important, my dear friends, to understand that it is the constitutional trust, it is the constitutional morality that goes beyond the constitutionalism, that goes beyond the fundamental human freedoms and human rights, which have been incorporated under Article 19 of the Universal Declaration of Human Rights, under Article 10 of the European Convention on Fundamental Rights and Fundamental Human Freedoms of 1950 and 51. So this is how we should try to understand. Because fair criticism must be allowed. Fair criticism should not be slogged in the name of the business interest. And unfortunately, my dear friends, these companies, only Google publishes data on the underlying rationale of the content removal request made by the governments. That data shows defamation and privacy and security as the leading justifications. Otherwise, Facebook has always been, the metaverse, headed by Mark Zuckerberg, has been very notorious in case of what we call of, entertaining removal requests about what we call, hate speeches and other important, violations of fundamental human freedoms. Because states are the primary duty between, or rather I should say the states generally bear the primary responsibility with regard to the ensuring freedom of expression, freedom of association and privacy. And there is a growing recognition, my dear friends, growing recognition, and this recognition has also been pointed out in the report of the United Nations Secretary General submitted as Roadmap for Digital Cooperation, that the private sector has an obligation. It is one of the arguments that has been, advanced in this particular, report submitted by the United Nations Secretary General, that private sector has a responsibility, has an international, obligation to respect these human rights. While companies may set their own limits on the type of expressions that may, and generally they allow, but at the same time, it is equally important, my dear friends, that for the sake of implementation, their policies consistently and provide redress where appropriate. It is the responsibility of the private sector. And the private sector is equally what we call owes a duty to ensure that each user respects the terms of what we call of services, including, for example, prohibition on violation of other users what we call rights to express themselves without being subjected to intimidation, any kind of a, what we call hacking, any kind of a internet what we call bullying, or indulging into any kind of hate speech. Therefore, in this context, my dear friends, private internet companies, and most notably metaverse holdings, including Facebook, Instagram, and WhatsApp, and the Google, Twitter, and other important what we call platforms, have confronted increased what we call scrutiny about their communities what we call standards and implementation of the same. Therefore, it is our responsibility that we should also at the same time, it is not only the responsibility of these companies, but at the same time, the people who have been visiting these websites, they also owe a responsibility that they should be mindful of this fact that the constitutionalized and constitutionally appropriate, morally appropriate what we call content and usage must also be ensured on the part of the users. I will continue, my dear friends. Thank you very much for the day. I got a meeting immediately after this class. A meeting has been convened by the department, so I take your leave to leave at this stage, and I would also share some of the important what we call readings, whatever we have deliberated today. So thank you very much. If you have questions, you may ask. Any questions? Yeah. Thank you. Thank you very much. Bye-bye.
Thank you.
You're welcome.